Hi, my name is Mr. Medananam. I'm the first presenter. Now, I will read the situation first. Tradex Senior Berhad had decided to cease its operation under Section 439, Section 1 of the Companies Act 2016 as the period fixed by the company for the duration of the company had expired. The company then passed a solution for members, voluntary winding up MPW, and appointment of Sarah as interim liquidator. However, it was barely 7 days later that the company found that the declaration of solvency had been totally negligently prepared where it involved a serious miscalculation. In fact, there are still several liabilities to creditors which are unable to be settled by the company within a 12 period. Now I will move on to the issue. Whether Sarah can cease the company's operation to members voluntary winding up MVW law. According to Section 465 of Companies Act 2016, circumstances in which company be wound up by the subsection 1, the court may order the winding up if subsection E, the company is unable to pay its debt. Now I move on to the section 439 of the Companies Act 2016, circumstances in which company may be wound up voluntarily. Subsection 1. A company may be wound up voluntarily. Subsection A. The period fixed by the Constitution for the duration of the company is expires, or the event, if any, occurs on the occurrence of which the Constitution provides that the company is to be dissolved and the company is in general meeting had passed a resolution requiring the company to be wound up voluntarily, or according to Section 432 of Companies Act 2016, modes of winding up. Subsection 2. A voluntary winding up may be affected by a resolution. Either Subsection A. It is when a company is solvent and a liquidator is appointed by the members during a members meeting. Subsection B. It is when a company is insolvent and a liquidator is appointed by the creditors during the creditors meeting. According to Section 443 of Companies Act 2016, Declaration of Solvency, Subsection 1, where it is proposed to wind up a company voluntarily, the director, or in the case of a company having more than one director, the majority of the director may. Now we'll move on to the Section 2 of the Companies Act. A liquidator includes the official receiver when acting as the liquidator of a corporation. Approved liquidator means a person who has been approved under Section 433 as a liquidator and whose approval has not been revoked. Section 440 of Companies Act 2016, Interim Liquidators. Subsection B. The meetings of the company and of its creditors have been summoned for a date within 30 days of the date of the declaration. The directors shall forthwith appoint an approval liquidator to be the interim liquidator after statutory declaration has been lodged with the registrar and uh, with the official receiver. Section 464 of Companies Act 2016, Petition of Winding Up. Subsection 1. A company, whether or not is being wound up voluntarily, may be wound up under an order of the court or order of the court on the petition of any one or more of the following. Subsection A. The company. Subsection C. A contributory or any person who is the personal representative of a deceased contributory or the trustee in bankruptcy or the Director General of Insolvency of the estate of a bankrupt contributory. Subsection D. The liquidator. Now I will move on to the case law. The name of the case is QB Hikmat Teguh Sdn Bhd against Pembinaan Legenda Unggul Sdn Bhd and ANO. The fact, when Pembinaan Legenda Unggul Sdn Bhd become insolvent and unable to continue its business, the members of the first defendant pass a special resolution to voluntarily wind up the first defendant and appoint the second defendant as its liquidator for the purpose of winding up its affair. Consequently, the first defendant was moved up by way of a creditor's voluntary winding up, and the second defendant was appointed as its provisional liquidator. On 2 November 2015, the first defendant company held a creditors meeting to lay out the statement of affairs of the company, consider the nomination of the second defendant as the liquidator, and consider the appointment of the committee of inspection. The creditors present at the creditors meeting were concerned about the conduct and outcome of this meeting, namely the absence of the company secretary at the meeting, the alleged lack of explanation by the first defendant as to the background to the affairs leading to the winding up, the disagreement on the appointment of the second defendant as the liquidator, and as to whether the creditors meeting had been lawfully adjourned. Held, in this case, Justice Nazlan held that in the event a director is incapable of signing a declaration of solvency pursuant to Section 433 of the Act, then the company ought to proceed with the creditors winding up instead of a members one. That's all from me.
Assalamualaikum everyone. My name is Muhammad Haika bin Wajib and I am the second presenter. So today I want to talk about the application of this case. So the first one is in applying section 439 subsection 1 subsection A of the Companies Act 2016, it appears that Tradex Sendirian Berhad had initially decided to cease its operation under section 439 subsection 1 of the Companies Act 2016 as the period fixed by the company for the duration of the company had expired. The second one is in applying section 432 of the Companies Act 2016, on the other hand, describe the different way in which a voluntary winding up can be effected. In this case, the company passed resolution for a member voluntary winding up, which likely involved a member meeting where the member agreed to wind up the company. The resolutions would have appointed Sarah as the appointed interim liquidator, who would, who would take over the management of the company affairs until a liquidator is appointed. In applying the situation given, the company appointed Sarah as an interim liquidator under Section 440 of the Companies Act 2016. This section outlined the process of appointing an approved liquidator to act as the interim liquidator after a statutory declaration had been lodged with the registrar and the official receiver. Applying to Section 443 of the Companies Act 2016 states that a declaration of solvency is made by the sole director or a majority of directors. In this case, it appears that the majority of directors in the company prepare a declaration of solvency that involved a serious miscalculation. This could have serious implications for the company, as the validity of the solvency declaration is important for the successful completion of the voluntary winding up process. If the declaration of solvency is found to be negligent, the company may have difficulty in completing the winding up process and may even face potential legal action. Therefore, the company must act swiftly to address this issue and ensure that the voluntary winding up process is carried out in a legally compliant manner. In applying this situation, the discovery of several liabilities that cannot be settled within 12 months jeopardize that the initial intent of member voluntary winding up (MVWU). Typically, MVWU is chosen when a company is solvent and its member believe it can pay off its debt within 12 months. However, with the newfound liabilities and inability to settle them within the specified time frame, the company may not meet the criteria for MVWU. This dilemma may lead to a transitions from member voluntary winding up to creditor voluntary winding up (CVWU). Creditor voluntary winding up is initiated when the company is unable to pay its debt in full. The company, in collaboration with its creditor, appoint a liquidator to sell assets and distribute the proceeds to creditors. In this case, the negligent preparation of the declaration of solvency and the miscalculation have put the company in financially unstable positions, necessitating the shift to creditors voluntary winding up to address outstanding liabilities. Unfortunately, in this situation, the creditor does not apply for the creditor voluntary winding up. In applying the case QB Khidmat Teguh Sendirian Berhad against Pembinaan Legenda Unggul Sendirian Berhad and ANO, Justice Nazlan emphasized that if a director is unable to sign a declaration of solvency, a crucial requirement for a member voluntary winding up MVWU, then the company should pursue a creditor winding up instead by the creditor not applying the CVWU in these situations. In that case, the company or Sarah as an interim liquidator should apply for the winding up through court based on section 465 subsection 1 subsection E of the Companies Act 2016. This implies that if Tradex Sindrian Berhad find its solvency declaration is negligently prepared, as in the given scenario, and still have outstanding liabilities to creditor, beyond 12 months, it might be more appropriate to switch from the planned MVWU to creditors winding up or by the court. So, in applying the situation given, Sarah, the company, and also the director of the company have a legal standing to file a petition for winding up the company under Section 464 of the Companies Act 2016. This means that they can start the legal process to have the company formally dissolved if they choose to do so. They do not necessarily have to file a petition, but they have the right to do so if they believe it is the best interest of the company and its shareholders. So, for the conclusion of this case is, Sarah cannot cease the company operations through member voluntary winding up (MVWU) because the company cannot settle its creditor debt, which make the company need to cease its operation through creditor voluntary winding up. But in these situations, the creditor does not apply the CVWU, and the company need to cease its operation through court. Thanks. That's all from me.
Hello, good evening. My name is Kennedy Lanana Michelle. I am the third presenter. Based on my situations, in the meantime, Sarah had also discovered several misappropriate transactions of Redex Sendirian Berhad funds amounting to RM 750,000 ringgit into the company managing director personal account since the past 3 years. In surprise, there are also several assets and properties of the company which had been misused by a majority of executive directors. Um, Advise Sarah on whether she has a local standby and can apply for a winding up by the court based on the above reasons. Now, the issue is whether the director have breached the director duties. Based on the laws of Companies Act 2016, Section 440, I will define interim liquidators. Subsection 1, where the director of a company have made a statutory declaration that subsection A, the company cannot by reason or its liabilities continue its business, and subsection B, the meeting of the company and of its creditor have been summoned for a date of the declaration. Um, the director shall forthwith appoint an approved liquidator to be the interim liquidator after the statutory declaration has been lodged with the registrar and with the official receiver. And based on the case or situation that I have read, um, it's also a point that Section 221 will be related to the case because it's also talk about disclosure of interest in contracts, proposed contract and properties of the office. Um, and the next section that will be includes in this case is Section 465, circumstances in which company may be wounded up by the company, and I will highlight on the subsection F, where is the director have act in the affair of the companies in the director own interest rather than in the interest of the members as a whole or acted in any other manners which appears to be unfair or unjust to members. Alright, we will move on to the cases related to the situations. We can see that on case Tengku Dato' Ibrahim Petra bin Tengku Indra Petra against Petra Perdana Berhad and another appeals 2018. The facts is Um, they are that decided that the case also provide guidance on what it means to act in a good faith and in the best interest of the company. The federal court in the recent case of Tengku Dato Ibrahim Petra bin Tengku Indra Petra against Petra Perdana Berhad and another appeals apply both subjective and objective tests simultaneously to assess the director duties and responsibilities depending on the different company cultures and company policies. The federal court emphasized that the subjective test depends on what a director considers to be an act done in good faith and in the interest of the company, and not what a court may consider as being in the best interest of a company. The court assessment would come in the form of an objective test whereby the court would examine the director's subjective assessment of what the director considers as being act done in the best interest of the company. Now we will move on to the applications. In application section 464 Companies Act 2016 outline the parties that have the right to apply for the winding up of a company. This section typically enumerates specific individuals or entities that have the legal standing or locus standi to petition the court for the winding up of a company. In many jurisdictions, an interim liquidator like Sarah may not inherently have the authority or locus standi to independently apply for a winding up by the court under Section 464. However, specific circumstances or legal provision might grant her such authority or eligibility. The typical party granted the locus standi to apply for winding up under Section 464 may include: the first one is creditor. Creditor owes a substantial debt by the company often have the right to apply for a winding up if their debt remain unpaid. The next one is shareholders. In certain situations, shareholders might have the rights to apply for a winding up, especially if the company afraid or being conducted in a manner prejudicial to their interests. And the next one is official liquidator or authorized representative. Sometimes an official liquidator or a person appointed by the company stakeholders, such as shareholders or creditors, may have the authority to apply for winding up. However, laws and regulations can vary between jurisdictions, and there may be specific provision that grant an interim liquidator like Sarah the authority to apply for winding up under exceptional circumstances or with specific court approval. The conclusion, therefore, Sarah can request for the compulsory winding up due to the problem based on the power of the directors, which are conflict of interest and misuse the company asset and equipment. That's all from me. Thank you.
Hi, my name is Nia Carson, and I take question number 2. Amar and Riza, two of the shareholder and director, various holding part, both not to take any dividend, but only to receive their monthly salary. Riza's wife, Liana, then joined the company as shareholder and director, and both husband and wife now takes control of it. Since then, there had been several major disagreements between Amar and the couple's direction, and their relationship had worsened and deteriorated from time to time. Having lost their passion, Riza and Liana had passed a resolution to terminate Amar, thus causing lost source of with utter dissatisfaction and disappointment. Amar had petitioned and waited a winding up order by the court. Issue of the situation is whether the court may order a compulsory winding up of Section 65 X 2016, Section 465, circumstances in which company may be wound up by court. Subsection 1, the court may order the winding up if subsection hash. The court is of the opinion that It is just and equitable that the company be wound up. Case: Ibrahimi against Westbourne Galleries. The primary legal issue in Ibrahimi against Westbourne Galleries centered around the rights of minority shareholders when they believe they have been unfairly treated by the majority shareholder. Specifically, it's questioned whether a court could intervene to provide a remedy for a minority shareholder under circumstances where the majority's action, through legal under company law, were deemed to be unfairly prejudicial or offensive. Ibrahimi against Westbourne is a landmark decision in UK company law that addressed the rights of minority shareholders and the principle of majority rule. This case is significant for its development of the concept of unfair in a situation where the majority shareholder may act in a manner that is offensive or unfairly prejudicial to the interests of the minority shareholder. Fact of the case involved Ibrahimi and Azhar, who is originally business partners, both in buying and selling drugs. They later decided to incorporate their business and became the sole shareholder of. A few years later, Nazar's son came of age. He was appointed to the board of directors, and Ibrahimi and Azhar both transferred shares to him. However, their relationship soured over time, and a dispute arose between them. After a falling out between the directors, Nazar and sons called a meeting and passed an ordinary resolution to remove Ibrahimi as a director. Ibrahimi applied to the court for a remedy to have the company wound out. The House of Lords recognized that while a company is a separate legal entity, there are situations where it can be treated as a partnership. In this case, the company's operation closely resembles those of a partnership, and the personal relationship and mutual confidence play a significant role. Ibrahimi had a legitimate expectation that his management role in the and that the article of association would not be used against him to force him out. The court considered it equitable for Nazar and his sons to use their legal right to oppose Ibrahim's decision by the court. The House of Lords held that it was just and equitable to wind up the company in this case. This decision was based on the unique circumstances, including the personal relationship between the parties, mutual expectation, and fact of the company structure and operation resemble a partnership. Application: in applying Section 465, Subsection 1, Subsection Dash of the Act 2016, the court is in the opinion that it is reasonable that the when 1. The substratum of the company is gone or no longer can be achieved. 2. The management is carried on in such a way that the minority is disregarded. 3. There is a deadlock in the management of. 4. The company was formed to carry out fraudulent or illegal business. The court would then consider the merits and the question and decide whether it was just and equitable for the company to be wound out. The court was satisfied that the conditions set up in the Section 465, Subsection 1, Subsection Dash were met. It could issue the order for the compulsory winding up of the company. In the case of Ahmad and Riza, Ahmad could petition the court for the compulsory winding up of Paris Holding Berhad under Section 465, Subsection 1, Subsection Dash of the Companies Act 2016 on the ground that there were major disagreements between the shareholders and directors which had led to the termination of Ahmad's employment and loss of income. In applying of the case of Ibrahimi against Westbourne Galleries Limited, which was a case which a shareholder in a company compulsory winding up under Section 99, Subsection 1, Subsection A of UK Companies Act 1985, following the company's decision to terminate his employment and right. The court held that the compulsory winding up was justified on the basis of the shareholder and engaged in that which was oppressive to the plaintiff Ibrahimi and had caused him to suffer a significant loss. Similar to the situation described in the question, which involved a shareholder, Amar, in a company Paris Holding Berhad petitioning for a compulsory running out of under Section 465, Subsection 1, Subsection H of the Act 2006. Due to a breakdown in relationship with the other shareholder, which was Riza and Liana, and loss of resulting from their decision to terminate his employment. In both cases, minority shareholder, which refer to Amar for the situation described in the question, and Ibrahimi for the sporting case, were ignored by the other majority shareholder in the management, resulting in both innocent parties were being terminated and losing their source of income. The action of majority shareholder were unfair and not a ground for just and for the conclusion, yes, the court may order a compulsory running up to the company since Reza and Liana's removal of Amar was an unjust and inequitable action given that they disregarded the minority, and it is just and equitable that the company be wound up. Thank you.
Hi, my name is Alexander Guan as the last presenter. The question given, acted as a liquidator, Azlan is required to ensure that the company's properties are being collected, used to discharge company's liabilities, and distributed among contributors, if any. Since the one-up order was obtained, he had first settled the creditors' claim prior to legal disputes, dividends to creditors, federal taxes, and company contracts without knowing any of their purposes and right ranking of distribution. Advise Azlan on his powers and whether he had discharged his right duties. So, the identification of the issue is whether Azlan has effectively exercised his powers and duties required to ensure that the company's properties are being collected and distributed among the contributors. The section used in this case is Section 2 of the Companies Act 2016. It outlines that a liquidator includes the official receiver when acting as the liquidator of corporation. A summary of similar cases: Bina Puri Sendian Berhad versus Jambalingan Senturaman Raki, Rimban Corporate Advisory Sendian Berhad 2012. The issue of this case is whether the liquidator had discharged his right duties. Back in this case, the creditors had been waiting since 2004 to recover their debt since the appointment of a liquidator, but the liquidator had failed to bring the liquidation process to an early conclusion. The court held that the liquidator has a duty to realize the assets of the insolvent company at the best possible price to maximize the amount available to the creditors of the company. Aside from the reason of liquidator's personal unfitness or the liquidator's personal misconduct, the liquidators may be replaced if the court is satisfied on the evidence that it is in the interest of the liquidation that the liquidator should be replaced. As for the application, in applying Section 2 in Companies Act 2016, this section gives the definition of liquidator. In applying Section 431, Subsection 1, Subsection A company may wind up by the order of the court. In applying Section 487 of the Companies Act 2016, it explains exercise and control of liquidators' powers. In applying Section 489 of the Companies Act 2016, it gives the settlement of liens and of contributors an application that a liquidator, Azlan, must fulfill. Power and duties of liquidator are vested in the 12th Schedule of the Companies Act 2016 for the one up by the court. Part 1, Section 472 of the Companies Act 2016, the power is the power exercisable without the court authority. Meanwhile, Part 2, Section 486 of the Companies Act 2016 is the power exercisable with the court authority. Though Azlan had settled the creditors' creditors claimed prior to the legal dispute dividends to creditors, federal taxes, and company contracts. It was known that he did not settle the distribution of assets according to the right ranking of funds to be distributed. Besides, Azlan did not know the purposes of those distributions done by him. The right ranking of funds to be distributed should be done according to the following ranking. The first is the federal taxes, the second one is the company contracts, the third one is the legal disputes, and the last one should be the dividend to creditors. As a liquidator, Azlan should distribute the assets based on the right ranking to be distributed. It is because the liquidator primary role in winding up process is to ensure that there is a fair distribution of the company's assets to the creditor or contributories. As, liquidator stands in fiduciary position to protect the interests of creditors or contributories, thus, he is required to perform his duties with a high degree of care and diligence. Based on the situation given, Azlan is not discharged from his duties as a liquidator as he failed to distribute the company's properties accordingly to the right ranking of funds to be distributed. Besides, he also failed to investigate the affairs and assets as he did not know any of their purposes of the federal taxes, company contracts, legal disputes, and dividend to creditors.